so what we're talking about today is quasi-contracts and Roman civil law. And again, knowledge is power. And once we start understanding this stuff and what the courts are saying, and we can defeat it. This is actually a definition taken from Black's Law Dictionary, 8th edition, and it's a definition on a subset. Now, um, the point I want to bring out on this is we're talking about the underlying portions. It talks about at the top there, it says based at first only upon exercise express promise. It was after supported upon an implied promise or even a fictitious promise. And that's a subset. But anyways, and then if you go on, it talks about and competed with equity in the case of essentially equitable quasi-contracts. Okay, so obviously um, equity is, again, if you watch the martial law video um, and the bankrupt corporations videos, what happens is they put the corporation into bankruptcy and thereby seize it, and then everything's under martial law. And under martial law, equity can do literally anything it wants. Without martial law, equity has to follow common law, and but under martial law, there's no common law, and all you have is equity. And so just so we understand what we're talking about here, and so is equity is dealing with quasi contracts, and that's the point I want to make here. um, this is actually taken from that book, Non-Ratification of the 14th Amendment, by this Judge A.H. Ellett of the Utah Supreme Court. And this is a war over the intrusion of civil law upon the common law. The court in Diamond v. Harris calls civil law superior equity. And this type for Diamond v. Harris is it's difficult to see how the courts of this state are to ignore the common law's rule of decision when it is made so by statute and adopt a civil law even though it have the merit of superior equity. That's a Texas court case. Anyways, and then it goes on to say, in the meantime, the civil law was the form of law imposed in the Roman Empire, which was largely, if not wholly, governed by martial law rule. Equity has always been understood to follow the law. To have superior equity is to turn things on their head. This is exactly what happens when martial law is imposed. If equity is the law, then it follows its own course rather than following the common law, thereby destroying the common law and leaving what is called equity in its place. And that's, what this non-ratification of the 14th Amendment in this area is talking about. It goes back to that assumptive definition that we were talking about, where under martial law, there's no common law. It's a military dictatorship, and everything's turned upside down, and equity can do literally anything it wants. And that's why these judges, you go in their courtroom and they'll say, I can do anything I want in here, and they can. And but again, this is all coming from martial law, from Roman civil law, the United Nations, and the Vatican, and it's all voluntary. Okay, that's why when you go into their jurisdiction, you can in a given case. Okay, so everything is divided down by cases. If you go and admit their jurisdiction, in a given case, they can do anything they want. They can change the rules. They can do whatever they want, and there's nothing you can do about it. If you want to have common law, then you have to stick strictly in common law, and that is extremely important. Once you go into civil law or their Roman civil law, then everything's open. They can do anything they want. It's a military dictatorship in there, and you need to understand that. And that's why I don't go in there. You can go in there. People go in there all the time, but then they wonder why they get railroaded, because that's exactly what happens. Both in Roman and English law, there are certain obligations which were not in truth contractual, but which the law treats as if they were. They are contractual in law, but not in fact, being the subject matter of a fictitious extension of the sphere of contract to cover obligations which do not in reality fall within it. And this is English publication. So we're talking about quasi-contracts here, and it's a fictitious extension of the sphere of contract, okay? So it's only dealing in the fiction. It can only deal in the fiction. Quasi or constructive contracts are based solely upon the legal fiction or fiction of law, okay? It can only deal in the fiction. That's why they have to fabricate evidence that you're a corporation, and they have to play all these little games, these judicial whores selling their justice. It is well settled rule of law that he who seeks benefit of contract must assume the burdens. Voluntary acceptance of a benefit of transaction is equivalent to consent to all obligations arising from it, so far as facts are known or ought to be known to persons accepting. And so, again, this is all in the fiction. And that's why they have to fabricate evidence. This judge up there, this whore, is not neutral or unbiased. He's working for the agency. I mean, there's court cases that talk about it. We're going to talk about it. This is all in the fiction. A quasi-contractual action presupposes acceptance and retention of a benefit by one party with full appreciation of facts under circumstances making it inequitable for him to retain the benefit without the payment of reasonable value. And again, it's all, you see, they're talking about equity again. And once they put that corporation into bankruptcy, then they can do literally anything they want. Civil law, Roman law, and Roman civil law are convertible phrases meaning the same system of jurisprudence, that rule of action which every particular nation, commonwealth, or city has established particularly for itself, more properly called municipal law. So civil law, Roman law, and Roman civil law and municipal law are all convertible phrases. Matter of fact, municipal law is the proper phrase. And that's why when you go into their kangaroo courts, it's under civil procedure, and that brings it all under the UN, because civil law and civil rules and municipal law are all found under UNIDROIT and the UN and the Vatican. This is taken from Black's Law Dictionary, 4th edition. Civil law, that rule of action which every particular nation, commonwealth, or city has established peculiarly for itself, more properly distinguished by the name of municipal law. This is an English publication. There's no judicial courts in America, and there have not been since 1789. Judges do not enforce statutes and codes. Executive administrators enforce statutes and codes. There have not been judges in America since 1789. There have just been administrators. Now, this is a bunch of cases, including the Supreme Court. Now, what you have to understand, again, is these judges are not, they're administrators. And we've talked about it in other presentations, how when a judge is representing a statute, when there's a statute involved, the judge is not a judge. He's a clerk for the agency. That's exactly what's going on. Even the U.S. Supreme Court is bought and paid for by the executive authority. This is Rule 45.1, U.S. Supreme Court Rules of Procedure. Process mandates all process of this court issues in the name of the President of the United States. You know, recently they had this Obamacare thing, and there was a U.S. Court of Appeals judge that was tearing a strip off a U.S. attorney. I think it was in Louisiana, and over this Obamacare, and then the next thing you know, Obama comes out and starts railing on the Supreme Court. And then when the Supreme Court heard this Obamacare decision, they caved right in, okay? Again, the U.S. Supreme Court is bought and paid for by the executive authority. That's exactly what's going on, okay? They're bought and paid for. They're all bought and paid for. This is taken from Commentaries of Gaius and the Rules of Ulpian, translated with notes in 1874. This Commentaries of Gaius and Rules of Ulpian is a book that was published in like 350 during the Roman Empire. Anyways, there's some very interesting stuff in here. And this is section 83. And it talks about a bunch of things. It talks about corporal stuff and incorporeal stuff. And it says, to take an instance, when a person has given himself for adoption or a woman has passed under manus, all their property is acquired by the adopting father, except those things which perish by capitis diminutio. Okay, well, and this is very important, okay, because this is what's going on all over the place. of which kind are a usufruct, okay, which is a type of a trust, an obligation to services on the part of freemen contracted by oath, and matters enforceable by a statutable action, okay? So what they're saying here is all statutes perish by capitis diminutio. Why do you think they're spelling your name in all block capital letters? That is capitis diminutio maxima. And so anything involving a statute is Roman civil law. That's exactly what it is. And capitis diminutio applies. And they go and convert your name in all block capital letters, or in Canada, it's media. They use media, which means the last name is spelt in all block capital letters and the rest of it's not, but it still perishes by capitis diminutio. And this is another section out of that same book. Capitis diminutio, the right of agnation, is destroyed, but that of cognation is not changed, because civil law doctrine may destroy civil law rights, but it cannot destroy those of natural law. Okay, and so again, even under Roman civil law, they only deal in the fiction. They have to get you into that fiction, because if you have natural law rights, they cannot do anything about it. And so these thieves, these whores on the courts, are busy converting you into this fictitious entity, because they are not neutral or unbiased. It's a kangaroo court from the beginning. Again, this is another section from that Commentaries of Gaius and the Rules of Ulpian. On the other hand, we can of our own free will make land religious by conveying a corpse into a place, provided that the burial of the corpse devolves on us, but it has generally been held that on provincial soil, land cannot be made religious, because in such land the ownership belongs to the Roman people or the Caesar. We're considered to have only possession and usufruct. Okay, usufruct is a type of a trust. Still, however, such a place, although it be not religious, is considered as religious, because that also which is consecrated in the provinces, not by authority of the Roman people, is strictly speaking not sacred, though and yet is regarded as sacred. Again, you know, the government, this stuff about taking the separation of church and state, that's not what the founding fathers intended. They just intended that the American government be not attached to one particular church, but they intended it to be Christian government. And the separation of church and state that's been going on from the 60s has basically taken our Christian government and turned it into satanic government under Roman civil law. And this is even talking about it, where under Roman civil law, provincial soil cannot be made religious. And then it goes on, it says, strictly speaking, is not sacred, yet it's regarded as sacred. And so again, this is all part of Roman civil law. This Commentaries of Gaius is another section out of there. This section 12 and 13 is talking about corporal and incorporal. Corporal things are those that can be touched, a field, a man, a garment. Incorporal things that cannot be touched. Of this kind consist in a right as an inheritance, a usufruct, and in any way contracted. Okay, so those are all incorporal things. And so a usufruct or a trust is incorporal. An inheritance, something that you can't touch, something that's fictitious. And this is another section out of there. It's talking about slavery. And since it is possible for a usufruct to be established over slaves and other animals, we must understand that usufruct over them can be established by session in court, even in the provinces. Now, when we said that usufruct admitted a session in court only, we're not speaking at random, although it may be established by emancipation. And emancipation is when they make you a slave, okay? Because remember, it was the proclamation of emancipation that freed the slaves after the Civil War or thereabouts. Anyways, although it may be established by emancipation also, in as much as it may be withheld in emancipation of the property, for in such a case the usufruct itself is not emancipated, although the result of it being withheld in emancipating the property is that the usufruct is left with one person and the property of another. Now, this is extremely important, because if you're a slave, you are property, okay? That's exactly what a slave is, okay? That's why they call slaves slaves. and because they are considered property. If you read those old court cases before the Civil War about slavery, the debate and the case was always over property rights, and that's what they're saying here, is that when they emancipate something, they only emancipate property. Okay, again, they can only deal in the fiction. Okay, this is all in the fiction, and they can enslave you in the fiction. The living soul cannot be enslaved, and this is the game that they play. These are these whores on the bench. They're bar member buddies, all coming from Roman civil law in the Vatican. Emancipate, to enslave, to bind, to die. That's Black's Law Dictionary, 4th edition. And emancipation, by the act by which one who is unfree or under the power or control of another is rendered free or set at liberty and made his own master. The term emancipation was borrowed from Roman civil law and is constantly used in the law of parochial settlements. So again, emancipation is it's taken from Roman civil law, and that was what they did to all the slaves after the Civil War. Another section of this Commentaries of Gaius, it is said that a partnership is dissolved by capitis diminutio, because on the principles of the civil law, a capitis diminutio is held to be equivalent to death. Okay, again, that's why they set up the Sesticate Trust, okay, because it's a dead thing. And that's why if you see all of the stuff they're doing is to dead things. It's under probate law. It's for dead things. And that's because capitis diminutio is equivalent to death. They're only dealing with dead things. They're dealing with an estate, with a fictitious thing. And this is it's the only way they can go. And they have to fabricate evidence of this dead thing. But at the partner's consent, and it goes on, it says the partner's consent to be partners still, a new partnership is considered to arise. The same name, I guess. Under Roman civil law, status is everything. The law of status, the category of law dealing with personal non-proprietary rights, whether in rem or in personam, is one of the 3 departments into which civil law is divided. That's Black's Law Dictionary, 8th edition. Freeman is a person in possession and enjoyment. Freeman is a status under Roman civil law. And in Roman law, it denoted one who was either born free or emancipated and was the opposite of a slave. Okay, so a freeman is a status. In feudal law, it designated an allodial proprietor, or as distinguished from a vassal or a feudal tenant. Gee, that sounds like Roman civil law. This is Black's Law Dictionary, 8th edition. This is about capitis diminutio. Capitis diminutio is the destruction or the kaput of the legal personality. Capitis diminutio, so to speak, wipes out the former individual and puts a new one in his place. And between the old and new individual, there is, legally speaking, nothing in common. A juristic personality may be thus destroyed in one of 3 ways: by loss of status, libertatis, okay? Remember, we're talking about status, okay? Capitis diminutio is status. This is capitis diminutio maximus, okay? So status libertatis is capitis diminutio maximus. That's when it's all block capital letters. By loss of status civitatis, which is capitis diminutio media, and by severance from the agnatic family. And that's capitis diminutio minima. And this is taken from Black's Law Dictionary, 8th edition, but they're citing a textbook of the History of System of Roman Private Law. Okay, again, this is private law. This is not, it's a contract. It's a contract. It's private law. Black's Law Dictionary, 4th edition. Capitis diminutio media, meaning the medium loss of status through the use of capitalization. See, John Doe is, that's how they do media, is the last name is all block capital letters. A lesser, a medium loss of status. This occurred where a man loses his rights of citizenship, but without losing his liberty. It carried away also the family rights. Capitis diminutio maxima, meaning the maximum loss of status through the use of capitalization. Highest and most comprehensive loss of status. This occurred when a man's condition was changed from one of freedom to one of bondage, when he became a slave. It swept away all the rights of citizenship and all family rights. That's Black's 4th edition. And what they're doing, if you think about it, is this capitis diminutio maxima is a war name. It's a nom de guerre, and so then a guerre is war. Ballantyne's Law Dictionary. Guerre is war, either public or private, so it can be public or private. Remember, capitis diminutio and Roman civil law is all private law. It's private, and so the key is to stay out of it. Literally, a ruse de guerre is literally a trick of war. A stratagem is said to be lawful among belligerents, provided it doesn't involve treachery and falsehood. And so, again, they're making war on you. And it's a ruse de guerre, because they're telling you what they're doing. They're spelling the name in all block capital letters. I mean, anybody that knows the law knows that they're doing something, that they're doing what they're doing. That's exactly what they're doing. There's even at common law, there's maxims that say that ignorance of the law excuses no one. And so if you can't figure it out, then it's your own ignorance. This is Cahill's Cyclopedia Law Dictionary, 1922. A nom de guerre is a noun and assumed name under which a person engages in combat or some other activity or enterprise. It's the original. It came from French. It literally means war game. That's taken from Oxford Online Dictionary. United Nations judicial whores are so-called judges who are actually not judges but are clerks operating for their agency and are bought and paid for under the Unidroit Treaty described herein. All UN judicial whores have a kangaroo court that's prejudged under Roman civil law, and it doesn't matter what you say or do. United Nations judicial whores routinely deny due process. United Nations judicial whores are not competent to do justice, which they themselves call it the appearance of justice, which is a fraud, as found in Corruption in the Courts, number 4. These UN whores are not neutral or unbiased, but are bought and paid for. This is it's a fundamental right of a party to have a neutral and detached judge preside over judicial proceedings. UN whores are selling their justice in violation of the Magna Carta. Magna Carta Chapter 40 says that to none will we sell, to no one will we refuse, delay, right, or justice. And they do it all the time. The UN judicial whores refuse justice if you don't pay their extortion. The UN judicial whores delay their justice so they can collect more royalties. They go and push it on to another hearing. Don't get me going. UN judicial whores, prejudgments. UN judicial whores have kangaroo courts. A kangaroo court is a self-appointed tribunal or mock court in which the principles of law and justice are disregarded, perverted, or parodied. A court or tribunal characterized by unauthorized or irregular procedures so as to render a fair proceeding impossible. A sham legal proceeding. That's Black's Law Dictionary, 8th edition. A summary proceeding. That's what they are, okay, is a plenary action. That's what goes on. If it's a judge alone, it's a summary proceeding, a non-jury proceeding that settles a controversy. If it's a non-jury proceeding, it's a summary proceeding, and it's a plenary action. It's a kangaroo court. The common law is wholly a stranger to summary proceedings. There's no common law in that court. That is not a common law. They'll put on a charade. They'll bring in a jury. They'll play all sorts of games, but it's not a true common law court, and the judge can do anything he wants. And that's Black's Law Dictionary, 8th edition. Plenary jurisdiction is a military dictatorship, as described in my recently released video about martial law. A plenary jurisdiction is taken from Black's Law Dictionary, 8th edition. A court's full and absolute power over the subject matter and the parties in the case. Absolute power. That's military dictatorship. Summary proceedings, another name for a star chamber that was abolished by England. This is a U.S. Supreme Court case. The corrupt star chamber courts of England required defendants to have counsel. Star chamber stood for swiftness and arbitrary power. Well, think about it. Arbitrary power, that's a military dictatorship. It was a limitation on the common law. In other words, there's no common law in there. When acting to enforce a statute and its subsequent amendments to the present date, the judge of the municipal court is acting as an administrative officer and not in a judicial capacity. Courts administrating or enforcing statutes do not act judicially, but merely ministerially. Ministerial officers are incompetent to receive grants of judicial power from the legislature, their acts in attempting to exercise such powers are necessary nullities. It's a fraud. Judges who become involved in enforcement of mere statutes, civil or criminal in nature and otherwise, act as mere clerks of the involved agency. They're a clerk. It's the accepted rule that not only in state courts, but of the federal courts as well, that when a judge is enforcing administrative law, they're described as mere extensions of the administrative agency for superior reviewing purposes, as a ministerial clerk for an agency. And they're a clerk. They're not a judge. They're bought and paid for. A judge ceases to sit as a judicial officer because the governing principles of administrative law provides that courts are prohibited from substituting their evidence, testimony, record, arguments, and rationale for that of the agency. Additionally, courts are prohibited from substituting their judgments for that of the agency. And that's a U.S. Supreme... no, that's not U.S. Supreme Court. That's federal court. Judge loses his absolute immunity. They don't have a shred of immunity from damage actions only when he acts in clear absence of all jurisdiction or performance of an act which is not judicial in nature. While when he's a clerk, he's not a judge, so therefore he is completely liable. When enforcing mere statutes, judges of all courts do not act judicially and thus are not protected by qualified or limited immunity. Officers of the court have no immunity when violating a constitutional right, for they're deemed to know the law. An officer who acts in violation of the Constitution ceases to represent the government. Imposters. That's what they are. They're imposters. They're masquerading as a judge. Those who falsely pretend, and think about it. This Roman civil law is private law. We already talked about that. It comes from the Vatican, okay? So why would it not be religious? It's exactly what it is. It's all coming from the Vatican. It's private. Anyways, those who falsely pretend an extraordinary commission from heaven or terrify and abuse people with false denunciations of judgments. And this is Tomlin's Law Dictionary, 1835. Williams' Law Dictionary, 1816, says basically the same thing. This is not something new. This has been going on for hundreds of years. And this is Burn a New Law Dictionary, 1792. Basically says the same thing, and it expands on it a little bit. This is Black's Law Dictionary, 8th edition. What was that, like 2009 or something? One who pretends to be someone who deceive others, especially to receive the benefits of a negotiable instrument. Well, how do you think these whores get paid? Where there is no jurisdiction, there is no judge. The proceeding is as nothing has been the law. Such has been the law from the days of Marshal Say. And that's a federal court citation, but they're citing Lord Coke. And they're also citing Bradley versus Fisher, which is the U.S. Supreme Court. A void judgment is one which has no legal force or effect whatever. It's an absolute nullity. Its invalidity may be asserted by any person whose rights are affected at any time and in any place. It need not be attacked directly, but may be attacked collaterally whenever and wherever it is interposed. And that's a Texas case. A void order may be attacked either directly or collaterally at any time. A void judgment is one which from its inception is and forever continues to be absolutely null and without legal efficacy, ineffectual to bind the parties or to support a right of no legal force and effect whatever, and incapable of enforcement in any matter or to any degree. And a void order, these are some English court cases. A void order results from fundamental defect in proceedings or from without jurisdiction or ultra vires act of a public body or judicial office holder. Without jurisdiction or ultra vires act is any act which a court did not have power to do. It wasn't a court. A void order is incurably void, and all proceedings based on an invalid claim or void act are also void. Even a decision of the higher courts will be void if the decision is founded on an invalid claim or void act, because something cannot be founded on nothing. In doing this, I shall have occasion incidentally to evince how true it is that states and governments were made for man, and at the same time how true it is that his creatures and servants have first deceived, next vilified, and at last oppressed their master and maker. A state like a merchant makes a contract. A dishonest state like a dishonest merchant willfully refuses to discharge it. And that's Chisholm versus Georgia, 1793. Obviously, the revolution was fresh in their minds, and so we had some decent judges, not like we have today. This is taken from Penhallow versus Doan's Administrators, 1795. Judges may die and courts may be at an end, but justice still lives, and those who may sleep for a while will eventually awake and must be satisfied. It is my opinion that well over 90% or more of the people who work as peace officers are honest, hardworking people who are very patriotic, take their oaths of office very seriously. Many of them have not been properly trained. Many of them are under pressure to generate revenue. The burden is on us to educate them since their bosses are obviously not doing it. So what can we do? We can lay a proper foundation so they cannot claim ignorance. Plausible deniability is their most powerful tool because the Supreme Court whores have given them qualified and qualified immunity. Demand a common law court and take away their plausible deniability so you can sue their butt off. Know what a true common law court is so you can tell if they really give you a common law court. Complain to the Judicial Council, which is basically a council of whores, to make sure you bring up the right issues. Complain to politicians. Make YouTube videos, circulate them around far and wide. The last thing they want is for people in general to find out what they're up to. Realize that it's never over until you say it's over. It's never, ever, ever over. Never, ever, ever give up. Always remember, we the people are the ones who are really in control, not a gang of Vatican judicial whores selling their justice, not their hired thugs, and not the Canada border pigs. We can refuse to participate in their de facto system. We can educate them ourselves about what a common law jury is and what the law of the land is. We can educate ourselves so we know when our rights are being violated. We can educate our public servants because many of them do not know any more than we do. We can educate other people by circulating this video and any other way possible. And we can demand a common law jury of our peers. We can work with our friends and neighbors to reestablish our common law juries and our common law courts. We can work with our friends and neighbors to get the United Nations out of America and Canada and anywhere else that wants to be free. The United Nations is the problem. That's where it's all coming from. There are nothing but a bunch of, it's owned and operated by the bankster thieves and their Vatican handlers. And that's exactly what's going on. If you really, there's an organization called Life Leadership that what they're doing is there's a world shift coming. It's really only 3 to 5% of the people who do anything. It was 3 to 5% of the people who precipitated the American Revolution, and the bankster thieves and their cronies are 3 to 5% of the people. Historically, every 100 years, plus or minus, there's a major change in our freedoms. It's called a world shift. In 1778, the U.S. Constitution, it was actually went on from 1776 to 1793, I think. The U.S. Constitution resulted, amongst other things, and so it precipitated a whole bunch more freedoms. In 1915, there was the 16th Amendment, the 17th Amendment, the Federal Reserve Act that started in 1913, actually, till about 1934. There was another world shift towards force, and the bankster thieves are responsible for that. Anyways, there's a world shift that's underway. You won't hear this about anywhere except from this Life Leadership people. And we're under a world shift right now. It's actually moving towards force, but it's not over. And the next 10 years or so is going to decide what happens. And then for the next 100 years, we're going to be affected by that. And so what these Life Leadership are doing is they're trying to educate people about these world shifts and raise up because all we need is 3 to 5%, and we need to be on point and know what needs to be done and work together to accomplish the ends. And so we need to make a world shift towards freedom. And so that's what the Life Leadership is trying to do. They provide educational material about what the issues are. They provide a way of bringing people together. They provide a way of generating revenue through network marketing. And this is the website. They have the 8 F's: faith, family, finances, fitness, following, freedom, friends, and fun. Following is leadership. their corporate leadership programs are used by corporations. There's airlines that when I was at U.S. Airways, they gave me the opportunity to take leadership training, and which I accepted, and so Life Leadership provides that same leadership training, and there's all sorts of ways that we can improve ourselves, and leadership is only one of them. And so there's 8 of them. We need a balance. We can't just concentrate on one area. Freedom's important, but our family's important also, and finances are important. If we're a slave to debt, then it doesn't do much good to be free if we're a slave to debt. They have CDs and DVDs that are available on Rascal Radio, potential constitutional changes. One of them that I particularly like is Townships, leadership development that corporations are using, financial fitness, adversity, success, and a balance. We have to have a balance. They do not just sign you up and leave you on your own. They want you a minimum of you got to be at least they help you. They help build your organization. Let me put it this way, and they need you to be successful so you can have influence and be a leader. We need 3 to 5% of the people as leaders so we can work together to affect change towards freedom. They have meetings every Tuesday night in the DFW area in the Omni Hotel on I-635 on Luna Road, just east of the George Bush Toll Road. There's other meetings. You can contact me if you want to find out about the meetings. And this is my personal website that where you can go and find out stuff too. Judgment Day is coming for these Canada border pigs and their judicial whores, and I'm looking forward to it. I'm looking forward to seeing some of them do that little dance they do at the end of a common law rope. There's common law courts springing up all over, and these judicial whores are going to be brought to some real justice, and I'm glad it's not up to me. That would defeat everything I'm trying to do. But I am really looking forward to seeing somebody like Rook the pig, Rook the whore, or some of these other whores do that little dance they do. I'd really love to see that. Upcoming events: corruption in the courts 4, taxes, do you consent, pursuit of happiness, which is compensation for labor, money, quasi-contracts and Roman civil law, fire the United Nations judicial whores in Texas, fire the United Nations judicial whores in Canada, City of Fort Worth pigs, City of Grand Prairie pigs. Those are some of the upcoming events. Copies of these documents can be found at my private group, and you can also send me an email. Obviously, you know about the YouTube videos. All bar members are foreign agents of the Crown, and the Vatican is described in the presentation about bar members. And the Crown is a corporation that's owned and operated by the Vatican, as found in the presentation on bar members. And I appreciate you taking the time to listen to my little rant today, and I hope you have a real nice day.